And remain standing until the conclusion of the reading of the proclamation. Ladies and gentlemen, the proclamation. All persons having any business before this honorable court now draw nigh. Give your attendance, and you shall be heard. God save the Queen.
I'd like to begin today by acknowledging the traditional custodians of the land on which we meet, the Gadigal people of the Eora Nation, and pay my respects to their elders, past, present and emerging. We gather here this morning to farewell the Honourable Justice Lucy McCallum, who leaves her position as a Judge of Appeal of the Supreme Court of New South Wales to commence as Chief Justice of the Australian Capital Territory. I am delighted we can hold this ceremony. It allows us, as members of the court and the legal profession, friends and family, as well as the wider community, the opportunity to show our gratitude for your outstanding contribution to the administration of justice in this state. This occasion is bittersweet. Although it is with great sadness and regret that we today bid you farewell from the court, upon which you have sat for 14 years, we are glad to know that it is only as a consequence of your appointment as Chief Justice of the Australian Capital Territory that we have to say goodbye. In an ideal world, we would have you carry out both roles. And if there ever a person capable of pulling that off, I've no doubt it will be you, with your boundless energy, which has rightfully earned you the nickname Energizer Bunny. Admitted to practice in 1986, called to the bar in 1991, elevated to silk in 2005, and appointed a Judge of the Common Law Division in 2008, you joined the bench at a remarkably young age. As Justice Simpson put it, you've had a very long non-parole period. I don't know if the Supreme Court of the Australian Capital Territory counts as day release. But the skill set required to achieve silk at such a young age and be appointed to the bench a mere 3 years later is reflective not only of your hard work and devotion, but also your intellectual rigour and intelligence. In January 2019, you were elevated to the Court of Appeal, where we bid you farewell today. The bench, and those who have come before you, have benefited greatly from the depth of expertise and life experience you brought during your 14 years as a judge of this court. You have enhanced the equality, diversity and confidence in this state's judiciary, and I have no doubt you'll do the same in the ACT as you serve out the remainder of your non-parole period or day release, whichever it may be. As a judge, you are always fair and unfailingly courteous. You give everyone in your courtroom the deepest and unwavering respect, even in the most trying of circumstances. Justice Simpson recalled your fortitude during the Feldman litigation, which involved a cacophony of curveballs, including troubling subject matter, complex legal issues, and a seemingly never-ending string of defences. I imagine your practising of handstands and chin-up in chambers greatly assisted you during those other trying times. Not to mention the $200 worth of Haig's chocolates you religiously sent your tippies to purchase and share with the entire floor. Your fellow judges can well attest to your habit of meticulous preparation for hearings. You maintain that brevity is a virtue, but not a shortcut, living by the fact that it can only be achieved by devoting lots of time to preparation. There is no better example of this than your management of the defamation list. You did this with unmatched efficiency. On a given day, you can sit on as many as 40 or 50 matters, delivering judgments ex temp at a truly remarkable pace. Your contribution to the court during the time you were the defamation list judge was quantifiably staggering. You're also known and admired through your beautifully written and thoughtful judgments. I wish the same could be said of me. You have a remarkable ability to balance the need for a consideration of the relevant legal principles with your deep understanding of the human condition. On this note, I recall your recent judgment in Lacey and the Attorney-General for New South Wales, wherein you wrote with great sensitivity and insight on Aboriginal cultural protocols of women's business and with respect to the hearing of sensitive evidence. Also note your poignant judgments in Vitality Works and Yelda No. 2 and Styles and Clayton Utes. You are, it must be said, a self-confessed bleeding heart. Be it a friend in need, a poorly animal, or even a grieving stranger, you're always willing to help. Off the back of the Katani trial, you acquired 2 dedicated court watchers. It was not uncommon for you to see the pair in the public gallery, often recognising them by the items of clothing they wore time and time again. One such item was a bright yellow scarf. Then one day you noticed that one of the court watchers was missing and the remaining court watcher was wearing his partner's yellow scarf. Before long you received a letter from the remaining court watcher thanking you for your work on behalf of his partner, whom he noticed sadly had recently died. You were deeply moved by his letter and you wanted him to know this. You proceeded to knit the surviving court watcher a multicoloured scarf in memory of his partner. You then invited him to a function at which you presented him with the scarf to express your thanks for their support. I think what makes a judge worthy of respect and admiration has a lot to do with how they spend their time away from the bench. This is particularly true of you. Any member of the public who asserts, as they do from time to time, that judges are out of touch with the community has not encountered you. Your contribution to the community is outstanding. I note in particular your time as Chief of the Nara Committee, of which you were incredibly proud. You worked tirelessly in this position to better educate judicial officers on matters relating to Aboriginal customs, cultures, traditions and society. In this vein, I would be remiss in failing to mention how you regularly spent your Friday mornings in Redford, typically alongside the present Governor-General and countless distinguished others, boxing with Aboriginal youth and sometimes inmates as part of the Clean Slate Without Prejudice program. Your selflessness and generosity with your time extends to your devotion to mentoring young lawyers. I'm told your value as a mentor derives in large part from the genuine enjoyment you get in seeing the younger generation realise their potential. Be it organising a chat over coffee with a tiffy who approach you out of the blue, or making time in your day to rehearse with your past associate during the duration of her bar course, you never say no to an opportunity to help. The fact that almost all your tippies over the years have kept in regular contact with you, and vice versa, is a clear indication of the impression you have made on their lives. That, and your seemingly endless list of hobbies, makes you a most interesting person to be well acquainted with. You are, of course, an exceptional role model for women lawyers. One of your past tippies described learning from you the importance of having camaraderie amongst women in the profession, that being an essential source of support and sanity. Another valued seeing your passion for the law alongside your passions beyond the law. As you have made your way to the pinnacle of this profession, you have remained true to yourself. You are incredibly down-to-earth, empathetic, and beholden to your capacity to care as a mother and friend, of course, but also in your role as a judge. Your discipline in balancing the different aspects of your life is deeply commendable and a vital example not only to female lawyers, but to the entire profession. No doubt your exceptional sense of humour has something to do with you being such a sought-after mentor. In 2020, you were the New South Wales Young Lawyers Patron, which saw you heading up the judging panel for what is described as the Golden Gavel, a comedic speaking competition for young lawyers. Of course, you took the task of delivering feedback seriously, using what you deadpan as the exciting new format of pre-record. This product was unlike anything I've ever seen produced by a judge. Amongst the constructive criticism and compliments on competitor submissions, you gave tidbits of wisdom, including a tip that young parents sing and dance to the Iggy Pop song, "I'm bored," to deflect a whinging child. You insisted we'll send them right away. If you are yet to do so, I encourage you all to watch the video. I assure you it'll be a very amusing 7 minutes of your day. All the while, you manage to be the most physically active person in the court. You're a keen runner of marathons. After all these years working for you, I'm still at loss as to why I believe you have completed 5 marathons, totaling about 211 kilometres. The thought of it frankly makes me feel physically unwell. I won't comment on how it makes other members of the bench feel. You have a passion for horse riding, or perhaps that's what you tell people to justify your rescuing of many horses in need. I know that if I was to list off all the sports you have participated in, I'd miss at least 5, one of which likely only started this morning, so I will not attempt to do so. Perhaps the best part about these stories is that they are not the least bit surprising to those who know you. You're an open book, always for the sake of bringing people together, and for that we are all the richer. You are incredibly capable, remarkably compassionate, and possess all the qualities of a great leader. For these reasons and more, you will make a great Chief Justice. The Australian Capital Territory is very fortunate. This court and the profession in this state will be much the poorer for your absence. Of course, we will miss you greatly. The blow of your departure is however, softened by knowing that you will truly excel in your new role. We truly wish you all the best. Mr. Attorney.
May it please the Court. I acknowledge the traditional custodians of the land on which we gather, the Gadigal of the Eora Nation, and pay my respects to their elders past, present and emerging. Your Honour, Justice McCallum, on behalf of our state and the Bar, it's my great pleasure to wish you well on your departure from your role as a Judge of Appeal of the Supreme Court of New South Wales and on your appointment as Chief Justice of the ACT Supreme Court, and to reflect on your significant contribution here. Your legal career included being a solicitor at Mallis and Stephen Jakes, as it then was, a prosecutor with the Commonwealth Director of Public Prosecutions and then the Queensland DPP, a barrister in private practice, and as counsel assisting the HIH Royal Commission. Your commitment to social justice was evident from the start of your career. You volunteered for the Redfern Legal Centre and have worked pro bono for asylum seekers in immigration detention and in environmental matters. In 1991, you commenced practice on the 6th floor at Selborne Wentworth Chambers, and you took silk in 2005 and were appointed to this court in 2008. Through all of this, you made sure that you were there for your 3 children, making a point of being home to have dinner with them, often working late into the night after they'd gone to bed. You've presided over many notable cases. A defining characteristic of your tenure has been your compassion, including for victims of crime, including sexual crime. Your judgments have acknowledged that there should be no false assumptions as to how witnesses and victims behave, noting, as you recently did in SM and against the Crown, that hesitation, requests for breaks and failure to recall detail are as consistent with trauma as they are with dishonesty. You recently wrote an article with Erica Timmins in Bar News about the lessons learnt in the Royal Commission into Deaths in Custody. In particular, you pointed out the challenges and considerations for lawyers in achieving fairer outcomes for First Nations bail applicants. In Vitality Works and Yelda, a sexual harassment case, it was argued that the material a woman found to amount to harassment was not explicit. You wrote, "In the nature of things, sexual implication is perhaps the most powerful of all. The suggestion that conduct cannot amount to sexual harassment unless it is sexually explicit overlooks the infinite subtlety of human interaction and the historical forces that have shaped the subordinate place of women in the workplace for centuries. You've shown endless patience with unrepresented litigants and with counsel, both experienced and inexperienced. On one occasion, a self-represented litigant in court decided to stand up and sing a song. Your Honour patiently waited for him to sing it through to the end and then said, "Thank you, Mr. Such and Such. You may now sit down." Other defining characteristics of your judgment are their care, precision and elegance. Understated humour is part of your arsenal. In a defamation case relating to an offensive email sent by a solicitor in a large law firm, you wrote, "It's difficult to decide whether it's more surprising that the remarks were made at all, after over a century of feminism, or that a lawyer recorded them in an email after over 7 centuries of subpoenas." Similarly, a few weeks ago in Lloyd against the Crown, you wrote, "Wherever one stands on the policy debate about general deterrence, that purpose of sentencing is not understood to require sentencing judges to send a strong message to would-be criminals that they should avoid a dysfunctional childhood." 2 important cases Your Honour presided over were the Cataney and Curtis prosecutions. In media coverage of Cataney, Your Honour was referred to as having a trademark stamina and attention to detail. The Sydney Morning Herald journalist wrote that your love of running marathons had earned you the nickname of Energizer Bunny after you delivered a judgment that reportedly took over 4 hours. Your Honour served as the defamation list judge from 2014 to 2019, and you were known as an efficient and well-liked judge presiding over some unique and novel defamation cases. These include what was thought to be the first case in Australia to consider whether Twitter was a separate publication of defamatory material. Schleifer and ASIC saw the application of defences of qualified privilege and justification to a complex and novel scenario. You've played an important part in recent defamation law reforms. You're known as a calm and reassuring judge. When barristers become flustered, you ask questions to help them get back on their feet. Apparently, only on one occasion have you been seen to be frustrated with a barrister in court. I hope this is not the second occasion. Your Honour apologised immediately, wrote a post-it note saying, "Be nice," and stuck it on your pencil case as a reminder for the rest of the hearing. I now move from Justice McCallum on the bench to a behind-the-scenes insight into Your Honour's chambers. Your staff often start their day with a recap of your morning exercise routine. This mostly or commonly features bouldering or weightlifting. You're known to be almost always in a good mood, but especially so when you've mastered a new climb or achieved a personal best at the gym. Some have observed the doorway above your chambers having a small plastic board with rock climbing grips attached to it so that you can practice there. It's said that the only time you've ever been annoyed at one of your staff is when you lost a pull-up competition on it. You regularly arrive in chambers in activewear. If enough staff see you on the way in, chances are you'll stay in activewear for a good part of the day afterwards. Your philosophy is, as you've already been spotted in it, there's no point changing. A few tipstaves recall that when they first met, Your Honour, you were strolling down the corridor in a singlet, leggings and socks. Despite your regard for physical health, you ensure chocolate is never in short supply in the court. A jar in the kitchen labelled "Treats for Tippies" is usually stocked with Haigs. It has a handwritten note saying, "Chocolate boosts your immune system," with a disclaimer. This is merely assertion for which there is no empirical evidence. A well-known legal journalist tweeted that you'd brought in chocolates for the lawyers on your last day presiding in the defamation list. You're well loved by your tippies. You've even jumped out of a plane with one. Your staff appreciate your care for them as they learn the ropes. In another life, you could have been an artist. You love drawing on documents, and the subject of your drawings are often your horses. And perhaps the biggest highlight of your move to the ACT is that you'll be able to keep the horses on your property rather than having to visit them an hour away from your Sydney residence. You're known for your generous streak. A highlight of 2 tipstaves' lives in lockdown last year was being asked to ride your horses so they wouldn't get lonely. And while there were a few good Christmas parties last year at the court, none beat the inaugural Supreme Court Ping Pong Championship you hosted in your chambers. Like a toddler's birthday party, all tipstaves who attended were sent home with a lolly bag full of chocolates. Your contribution to the legal profession has been significant. You demonstrated a particular concern about the overrepresentation of Indigenous people in the criminal justice system. As the Chief Justice said, you chaired the Judicial Commission's Nyara Yura Committee. The program was established in 1992 in response to the final recommendation of the Royal Commission into Aboriginal Deaths in Custody, The judicial officers should receive instruction and education on matters relating to Aboriginal customs, culture, traditions and society. You were on the Judicial Council on Cultural Diversity in 2017 and 2018. You regularly assist in judging moots for diverse women in law. Mentoring young lawyers is one of your specialties. You provide encouragement, advice, home-baked cakes, and of course chocolates. Justice McCallum, you are the most active judge on the bench of this court. You rock climb, surf, mountain bike, and do yoga. You were placed second in the Spartan race in Canberra a couple of years ago. You're known as warm, approachable, and down to earth. His Honour the Chief Justice told an anecdote about a couple of long-standing court attendees, and I think this is the same anecdote. You received a letter from one of them that had said you were a great enhancement to the bench, given that you had in spades the greatest quality that a judge needs, and that is compassion. And the other wrote, he concurred. The letter said there was no need to reply, but reply you did, saying, I'm sure you know it's a central principle of our system of justice that courts must be open to the public and must carry out their activities in public. This is a fine and important principle, but one that rings hollow if the public to whom it is directed is eternally absent. Without observers to oversee its operation, open justice feels like an empty deal. You went on to write that you saw the two, Dennis and Robin, as guardians of your court. It's a wonderful illustration of your sense of justice and humanity. Justice McCallum, congratulations on your appointment as Chief Justice of the ACT Supreme Court, and thank you for your many years of wonderful service to this court and to the wider New South Wales community. I offer you the warmest of wishes for your continuing career on the bench. May it please the court.
Ms van der Plas.
May it please the court. I too acknowledge the Gadigal people of the Eora Nation, the traditional owners of the land on which this court stands, and pay my respects to their elders past, present and emerging. I also acknowledge any Indigenous Australians present today. I come before the court on behalf of the Solicitors of New South Wales to farewell Your Honour from this court and to welcome and acknowledge your appointment as the next Chief Justice of the ACT. Since being admitted to the role of solicitors in 1986, Your Honour has established an impressive legal career defined by your empathy, your energy and your excellence. While your colleagues have lauded your intellectual rigour, they noted that your most distinguishing quality as a lawyer, and now a judge, is your empathy. To quote one of your colleagues, whether in the courtroom, writing a judgment in chambers, or chatting to tipstaves in the corridors, Her Honour approaches every conversation and task with thoughtful consideration, what it might be like to be in the shoes of the person before her. Your Honour's concern for your fellow citizens has deep roots and was evident even before your legal career began. As a student at UNSW, Your Honour volunteered at the Redfern Legal Centre and helped create a program to teach legal rights in disadvantaged schools. Empathy made you a fair commercial litigator. It informed your thriving private practice at the bar, and it explains your long-held passion for pro bono work. It also shines through in your judgments from this bench. In a recent decision, Your Honour handled a matter that contended with Bugmy principles. Bugmy reinforces a long-standing legal principle that the circumstances of someone's background, regardless of their race, must be given proper weight by sentencing judges. In your judgment, Your Honour reflected upon the importance of not using people who have suffered significant childhood disadvantage for the purpose of general deterrence. The wisdom in avoiding, in your words, lawyerly arrogance when considering the credibility of the expert evidence of medical practitioners. And most importantly, the critical role Bugmy plays in principles of fair and just sentencing. It was, as they say, textbook McCallum. Deep reservoirs of empathy and insight, bounded together by intellectual rigour and respect for precedent. Your Honour has always championed the view that law should serve everyone, including the disadvantaged and marginalised, and been admired for it. To your empathy, we must also add Your Honour's remarkable energy and drive. Your Honour's stamina has literally made headlines, such as when you delivered a meticulous and well-considered judgment that exceeded 4 hours in length. A solicitor that used to brief you was in awe of your ability to run a busy private practice, raise 3 wonderful children, and have so much fun doing both. Many people point to your long hours spent running to explain how you sustain this formidable work ethic. But energy is about more than fuel. Your Honour also harnesses the energy in the room, putting people at ease. To quote a former tip staff, Your Honour has always made the chambers a happy and healthy place to work. Her humour and humility are what I strive to achieve. A case in point, in the lead up to holiday season last year, a Christmas tree was erected in your chambers, decorated with tinsel and baubles. Rather than the traditional angel on top, a printed photo of Your Honour was given the pride of place. Your Honour's feedback was typically self-deprecating. It needed to be prettier. I would like the court to note that the picture itself was left intact. However, a border of gold stars was quickly added. This energy and your passion for people and the law is infectious. Your colleagues have appreciated how it leavened serious moments and put them at ease. The final characteristic I wanted to note today is your lifelong commitment to excellence. Every person interviewed to help prepare these remarks lauded your calibre as a legal practitioner and judicial officer. In reflecting upon your legacy on the bench in New South Wales, one of your fellow justices noted that Your Honour has changed the conversation and legal writing in this state around how the less fortunate, the dispossessed, injured and broken are spoken about and treated. Her Honour has accomplished this in her writing by deploying turns of phrase that illuminate the real question without polemic. The fact is the law is now different after having encountered Your Honour. Your contribution over many years and across multiple roles have promoted a fairer justice system, and we are all the beneficiary of it. As the President of the Law Society of New South Wales, it is my pleasure to thank you for your contribution to the administration of law in New South Wales and wish you well on your new beginning as Chief Justice of the ACT. Everything you have done and everything you have achieved augurs well for a very successful tenure as the new Chief Justice. On behalf of the Solicitors of New South Wales, I thank you, Your Honour, for your service to our state. As the court pleases.
I acknowledge the traditional custodians of the land on which we meet, the Gadigal people of the Eora Nation, and pay my respects to their elders, past, present and emerging. I acknowledge the wrongs that have been done to First Nations people under white rule and the triumph of their resilience and their culture. Thank you, Chief Justice. It has been an honour to serve under your calm, wise and sometimes inaudible leadership. You have literally led the court through flood and pestilence. Your successor knows he has big shoes to fill and has come to understand that the role of Chief Justice of New South Wales is as much about preparing for the next natural disaster as it is about stewarding the jurisprudence of a strong court. He is said already to have started stockpiling party pies and French Chablis, just in case. Thank you, Attorney, for giving me the opportunity to serve on the New South Wales Court of Appeal. I hope I will be forgiven in this intimate setting for saying that I could have wished for more female company on that court. But it is an extraordinary collection of great minds, and it has been my very good fortune to have the privilege of working with such people, even the blokes. It was also a great privilege to serve on what the Chief Judge at Common Law calls the working division of the court, the Common Law Division, and it is indeed an extremely hard-working court. Its judges are incredible. Thank you also, Attorney and Ms van der Plat, for your kind words. Regrettably, it is the convention for speakers at ceremonial sittings not to tell the whole truth. As nice as it has been to hear my praises sung, I feel compelled out of honesty to present a more balanced appraisal of my time on the court. A number of my judgments have been described as wrong. Some even plainly wrong. And although that has mostly been by way of constructive criticism from my colleagues on the Court of Appeal, I'm sure it is always said with love. Others have been less kind. A litigant in person once told me that my mind was in a state of gallimaufry. The original meaning of that word is an unappetising dish. It has come to mean a confused jumble or medley of things. Another self-represented litigant told me that he would not address me as Your Honour because he saw no honour in me. He said he would address me as Woman McCallum and proceeded to do so for the rest of a 3-day hearing. I found this particularly disturbing because that is also how Jed, my partner, addresses me at home. Although in a concession to recent events, he now says, Chief Woman McCallum, get me another beer. Once during sentencing proceedings for murder, a person in court called out that the sentence I had imposed was manifestly inadequate. Unusually, that person was the offender. These are all true stories. He believed that he had committed the perfect crime and ought to have earned the accolade of receiving the maximum penalty of imprisonment for life. He was evidently more than a little offended when I disagreed. I have it on good authority that he later made an application to legal aid to appeal against my erroneously lenient sentence. One year, I faced 2 recusal applications within months of each other. In one, I was asked to recuse myself because, as is common knowledge, I am a right-wing pro-Crown empty suit. In the other, the basis for the application was that my mother was a social worker and a communist. I don't have a problem with being challenged as to my authority to hear a particular case. I just wish these people would make up their minds. Possibly the only positive popular feedback I've had as a judge was from Ray Hadley, who declared on public radio, I don't know if I've ever met Justice Lucy McCallum, but I like her. He liked me because I had rejected an argument that the possession of cannabis is not an offence known to law, because according to Genesis 1:29 of the King James Version Bible 6:11, all plants, obviously including marijuana, were given to man by God. These are all extreme illustrations of what I would see as the bilateral nature of the rule of law. As with a defamatory publication, the dispensation of justice is not a unilateral act. We have, during the pandemic, faced the hollow experience of publishing a judgment to an empty courtroom. It feels incomplete. Justice is only served when it is received and comprehended by the people we serve: offenders, victims, litigants, advocates, court watchers, students, and the public at large. We may feel that we explain our reasons for decision in terms that are comprehensible because they explain a result by reference to rules that are fixed and certain. Probably the most important lesson I have learned in the last 14 years is the fallacy of certainty. The clearest statute or common law rule will never address the infinite variety of human experience or the different ways in which people perceive the same events based on their own experience of life. We may begin with the specification of a taxonomy for the question raised for determination, such as asking where an offence sits on the range of objective seriousness, or whether a risk is obvious, or whether conduct was unconscionable, and seek to place the case within that taxonomy. This is all well and good, so long as we keep our eyes on the higher principle and never forget that the task is not only to act according to law, but to do right by all manner of people according to law. The law is difficult and messy. In every area of law, there are principles that overlap and contradict each other. I have often heard lawyers, young and old, chastise themselves because they can't immediately see the right answer to a legal problem. If the answer is uncertain, that is often a reflection of the messiness and uncertainty of life. In my application of the law, I think I would rather have my mind likened to an unappetising dish or a confused jumble or medley of things than be accused of having adopted a rigid taxonomy ill-fitted to the case at hand. Mr. Attorney, you mentioned the defamation law reforms, and I have been privileged to be invited to sit on the expert panel you convened to advise you on the reviews of the uniform defamation laws. As I have said to you in person, the process adopted for those reforms is the paradigm of a robust, inclusive process of consultation with all stakeholders, plaintiffs, plaintiffs' lawyers, defence lawyers, media, academics, bloggers, service providers, and the public at large. In what is perhaps an unexpected parallel, a similarly robust process was undertaken in the formulation of the Uluru Statement from the Heart. When the task is to achieve consensus among geographically and culturally diverse mobs of Indigenous people spread across the nation, the process of consultation with stakeholders takes on a whole new dimension. My former tip staff, Tila Reid, was involved in that process during the year she worked for me. Tila, who is now in higher demand than anyone in this courtroom, is downstairs in my chambers weaving her oratory magic, and I'm pleased to say will join us for morning tea. But I'm honoured today by the presence of Thomas Mayer, one of the champions of the Uluru Statement, who I know will be more than happy to discuss it at morning tea with anyone who is interested. I ache for the day the Speakman approach to defamation law reform, which is also the approach of First Nations people to constitutional reform, is adopted across the board as the model for community engagement in the rule of law. When the call of the angry mob for law and order is met with an invitation to a law and order roundtable discussion, joined by experts and people who understand and have lived a variety of experience. Victims, offenders, police, elders, psychiatrists and psychologists who understand trauma and mental illness, medical practitioners who understand addiction, social workers, and perhaps even my mate Ray Hadley. I owe an enormous debt of gratitude to so many people in this room for their love, support, mentoring and guidance over the years. Even the categories of people to whom I'm indebted is long enough. Fellow judges, my 4 former associates, my many former tipstaves, court staff, people in the registry, sheriff's officers, advocates who've helped me understand things I didn't understand, solicitors, and of course my family and friends and loved ones. I couldn't begin to name you all individually, and I hope I don't need to. You all know what you mean to me.
Court will now adjourn.
This honourable court is now adjourned. God save the Queen.